Hi, everyone. Thank you for joining us today for Constangy's webinar, Pay Equity Report Card. How are we doing in 2025? A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenter may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Her contact information will be included in our post-webinar follow-up email. This program is approved for Sherman HRCI credits. We will be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we will also be sending out a copy of the slide deck along with a recording of today's session. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm pleased to introduce today's presenter, Lara de Leon. Laura is a seasoned trial lawyer with more than 2 decades of experience representing companies of all sizes and complex employment matters. She has successfully defended clients in court, before agencies, and on appeal, and also partners with organizations to navigate issues such as discrimination, retaliation, wage and hour compliance, and pay equity. Drawing on her experience as both outside counsel and in house counsel for multinational corporations, Laura brings a practical and strategic perspective to the workplace challenges employers face. And now I'll turn it over to her to kick off today's presentation.
Thank you, Victoria. Hi, everyone. I'm very glad to be talking to you today about our pay equity report card update. It's a good time to touch base and check in and see what's new or maybe not new in the area of pay equity. And we'll talk about some really interesting cases and developments, and then hopefully have some good practical tips for folks to take away in order to ensure that your organizations are doing all they can to continue to ensure compliance in this very important area. So let's just kind of get started and get all on the same page, or get in step if you like silly puns. You might say, what do the Dallas Cowboy cheerleaders have to do at all with pay equity? Well, those of you who are reality show fanatics and or children of the 70s, like myself, the Netflix show America's Sweethearts will resonate with you deeply. And those of you who are fans or who are just into pop culture and see headlines will know that an undercurrent of the latest episode or the latest season of the DCC show dealt with pay equity and dealt with a number of the members of the DCC squad trying to argue and advocate that they get pay equity, and not so much, in the gendered sense, being paid commensurate with similarly situated male peers, because of course there are no guys on the DCC, but from the concept of what is fair and equitable in terms of what they bring to the organization and overall, value that they bring. So it was a really interesting subtext, really interesting lesson for it. And what was really kind of striking about how all that transpired was really the success that they had. And you probably saw some of the headlines where they achieved a 400% pay raise at the end because of all those efforts. And so levity aside, I think that kind of has some learnings for us as employers, and for those who are really interested in pay equity in the organization. And it just really underscores how prevalent pay equity is and fair pay is in our current culture, in our current society, and kind of underscores that it's really not going anywhere. So moving on to kind of a more drier topic, let's talk about some statistics and information that we have. So where are we in 2025 in terms of the US gender pay gap? For the last several years, there's been a lot of attention on this. We see lots of reports and studies every year about the progress of the US gender pay gap. We have this unofficial holiday called Equal Pay Day, where is the time period in the current year where women would finally catch up to men in terms of pay from the prior year. So obviously the earlier in the year that the Equal Pay Day happens means we're making progress in shortening or closing of that gap between men and women, at least based on the uncontrolled gap. What was kind of interesting is Equal Pay Day was March 25th of this year, but it was March 12th the year before, which shows a little bit of a retrenchment, kind of moving in the wrong direction for that, but not significantly. But let's look at some of the data, and this data on here, at least as far as on the left-hand side of the slide, the uncontrolled and controlled data came from a Pew data research report. There are not any number of reports you could look at. And just in terms of what this report indicated was that for the uncontrolled pay gap, and for 2024 data, women earned an average of 85% of what men earned. And then the prior year, they had earned 81%. And then with the controlled pay gap, women earned an average of 91% of what men earned in 2024. I actually saw another study that said 95%. But the data is showing that the gap is sort of stagnating, maybe moving backwards, maybe inching forward incrementally, but it is still there. Now, you might be wondering or need a refresh on what the uncontrolled pay gap is versus the controlled pay gap. And so just recall that an uncontrolled pay gap just looks at the median salary between men and women in the workforce. It doesn't take into account factors like job type, experience, or education. In contrast, the controlled pay gap actually looks at the data with those factors in mind. So it's intended to be a little bit more of an apples to apples approach to looking at this information. Some interesting conclusions drawn from the uncontrolled pay gap are we still are seeing the effects of what has been coined this motherhood penalty, where women, it's not just women who are lagging, but the lag increases for women with children. And, that could be due to any kind of number of things. I mean, it could be to self-selection out of the workforce. It could be self-selection into lower paying jobs or jobs that have more flexibility. It could be to any number of factors, but that is still a really prevalent point or theme that we're seeing. Now, in contrast to that, I saw one study that looked at the pay of men who had children, men in the workplace who had children. And ironically, men who had children actually earned more money than their peers, their male peers who did not have kids. So there's a motherhood penalty and a fatherhood bump that seems to be taking place in our workplaces, which certainly bears some, probably bears some looking into and teasing out to see what's really driving that. Now, with respect to age, this was some really interesting information. In 2025, the EEOC had actually issued a report about the gender pay gap in the federal workplace. And while this is interesting, is if you work in the federal workplace, you have a pretty strict salary structure, right? Which people think has a little less discretionary component to it. But in any event, the EEOC released some information about their pay analysis, and that showed a pretty significant age component as well, where the age gap was larger for workers who were over 40, as opposed to those who were under 40. So the wage gap between men and women was smaller for workers aged 25 to 34 than it was for all workers 16 and older. And then in 2024, the EEOC reported that women aged 25 to 34 earned an average of 95 cents for every dollar earned by a man in the same age group. And then by comparison, the gender pay gap among workers for all ages that year was 15%. I mean, it's 15 cents. Sorry about that. So smaller workforce, or the younger workforce, has a smaller gap, but as we get older and progress through the workforce, the age gap widens. And that could just be a situation related to kind of the legacy pay structures that employees tend to carry with them during their employment life cycle. But that was still a really interesting sort of analysis that looked at how does age work as opposed to, just gender in a particular situation. So, what else is going on in the world today? We got a lot going on in the world. I am often reminded of this quote, which is either Heraclitus or Yogi Berra, that says the only thing constant in life is change. And we certainly have had a lot of change from a legal and regulatory perspective this year, especially on the federal front. A couple of issues have kind of tangentially touched on the pay equity space, but we are still seeing a lot of activity on the state level. So just for some food for thought from the federal perspective, earlier this year, March, April, May timeframe, we saw a flurry of executive orders being issued that really tackled a lot of DEI efforts and affirmative action efforts as well. So two of those I just wanted to point out a little bit and mention their tangential impact to our pay equity efforts that we might have as just an employer in this country. You might recall that there was an executive order issued on April 23rd of 2025 called the Restoring Equality of Opportunity in Meritocracy. And the net sum of that executive order was to dismantle or undercut this whole disparate impact theory of discrimination liability, where an employer has a facially neutral policy that tends to have a disproportionate impact on a protected class. And so the direction was to the federal government really is to stop using that or reduce reliance on the disparate impact theory for finding liability or filing lawsuits or finding compliance issues. Notably for private employers, aside from maybe getting, a lower risk of investigations from federal agencies, note that Title VII of the Civil Rights Act of 1964, which is the statute we mostly operate under in this space, that has codified disparate impact. So this executive order does not affect how we should be looking at our data, how we should be looking at our employment or pay policies in any way, shape, or form. But it just is a really, interesting notion in terms of what we're seeing from the federal government and what we might be seeing from agencies who might be refocusing their enforcement efforts. Now, the other EO that I wanted to mention before we start talking about state law issues is in June of this year, the government basically has defunded the OFCCP and has directed their actions to not require any more affirmative action planning. And that is my super high level overview of what that situation is. There are a lot of details I'm leaving out deliberately for that, but those of you who were federal contractors as part of your yearly affirmative action obligations, we're doing a compensation analysis for that, right? And so that has now been removed as a requirement, but leaves a lot of employers to say, well, what do we do now? Do we still do these on a voluntary basis? How can we possibly keep our finger on the pulse of our compensation practices now that we don't have this requirement that we can tout to our business leaders saying we have to look at it every year. And so we'll get into that a little bit later. But those are the main things, like I said, I wanted to just touch on from a federal level that impact pay equity. But let's turn to the state level because that really has been where all the action has been with respect to steps that employers need to take in order to address pay equity concerns. And this has been the case for a very long time. I'm going to say at least 5 to 7 years. We have not seen any significant legislation or action on the federal front that really stuck. So we've seen a lot of action on the state level, right? So on the state level, we are continuing to see piecemeal legislation that is requiring employers to be more transparent with their salary ranges and benefits. And the whole idea is to promote fairness and equity in the workplace. It all kind of boils down to this belief that Number one, women tend not to ask a lot compensation wise. I think we've done a lot better over the past several years. But coming in, women are more prone than men to sort of undercut their salary expectations for the hopes of getting a job. And then the other thing is that, we have that baggage that we take with us throughout our career, because pay increases tend to be based off of a percentage of what we're earning. If we come in at a low ball number, over time, we're not going to be making as much as our peers are who came in at a higher rate of pay, right? So this transparency laws are really aimed at trying to level that playing field at the outset of the employment relationship, right? So we've got different variations on this theme, requiring employers to disclose salary ranges to applicants at a specified point during the hiring process, whether it's in our postings, or to them upon request, or after a conditional offer is extended. There is also this prohibition that a number of these laws have against employers asking what an employer applicant actually makes currently, so they can't use that in conjunction with a hiring decision or a compensation decision. So we are just seeing more and more states kind of pick up on that and carry forward with that strategy for addressing it. So this map I thought was very interesting. This came from, I believe it came from Paycor. And so if you Google it, you'll kind of see, their great color-coded map that highlights where we've got statewide laws, where there are bills pending, where there might be a local law that you need to pay attention to, or no laws. And what's always kind of interesting to me is how many states still have no law on this. But what's happening is those states that have passed laws, particularly if you are a multi-state employer, what I've seen are a lot of clients are not differentiating so much what state the jobs are in. They're just saying, we're going to provide this salary range information or whatever it is we need to provide on a more enterprise level, whether it's just ease of use. It's easier just to have a one size fits all approach, or they're like, this is a great idea. We really have seen results by promoting our pay ranges, and so we want to do it everywhere. I still do see some folks who opt for a state by state basis, especially where their jobs are particularly localized, and they're not open to a national candidate pool. But there are a number of ways you can really address that issue. But we still are seeing, I think it's about like 15 or 16 states where we have these different requirements. I'm not going to go through each one for you, but there are a couple of new ones out there that are of interest. Illinois, for example, their pay transparency rules went into effect in January of this year. In Massachusetts, for those of you in Massachusetts, I believe those take effect on October 29th. And then note that Massachusetts has a data reporting requirement as well that's coming into play. It used to be under or at least a prior version was if you did your own voluntary pay equity analysis and then faced a lawsuit for pay equity issues, you could use the fact that you had done an analysis as a safe harbor affirmative defense. But now it's going to be a annual reporting requirement, kind of similar to what California has in place as well, but that's coming soon. Minnesota came into effect this year. New Jersey went into effect in June this year. Washington State's kind of interesting. That's their pay transparency has been on the books for a while, but their case is unique in that, or their statute's unique in that it allows for a private cause of action. And so we're seeing a lot of lawsuits being filed in Washington on typically on a class action basis, challenging an employer's lack of compliance with the salary range posting rules. So that's kind of an interesting development and a little cottage industry that we're seeing developing in this space. So how are employers responding over the past couple years, or how have they responded over the past couple years to this increased scrutiny, from the state legislatures, from lawsuits, just from the general increased awareness that we've seen over pay equity in the workplace. So this information is from an affirmative study entitled How to Respond to 5 Major Findings from the Future Pay Equity and Transparency. So they did this study. This report provides a look at how organizations are responding to increasing employer and lawmaker scrutiny on key pay topics. So some of the key findings were this, and I'm kind of interested about how your organization stacks up with this. But 2/3 of the respondents believe that pay equity will improve their organization over the next 2 years. Only 9% said they did not see it improving in their organization in the near future. 25% of respondents already said they already believed that their organization was equitable. So so the fight is still going on, I guess. So that's kind of interesting. I always kind of am curious about those who say they believe their organization is equitable and what they think that's based on, but hopefully they're doing some internal analyses to kind of evaluate that. 35% of organizations did not conduct a pay equity analysis in 2024. 42% had conducted it with an internal team, 3% relied entirely on experts, and 18% said they had used both. And this is an interesting issue, for those organizations who, are thinking about how to do a pay equity analysis. How do we get buy-in, and assume we do get buy-in to do it? Who's going to do the work? And there are a lot of resources out there that enable employers to do this work. It does look like, a lot of them are, utilizing their internal team. And I guess that would depend too on the expertise and your data. We're not going to go into the nuts and bolts of how to do a pay equity analysis on this webinar, but, a lot goes into it. But this is really interesting data. And my next slide will talk about attorney-client privilege in doing audit reports. I didn't see that was addressed necessarily in this particular study, but we'll talk about that interesting component in a slide or two. But going back to this study, they talking about pay transparency. What do you guys do? What did the study respondents do with respect to including salary ranges in some of their job postings? 80% said that they actually include salary ranges. 40% said the org does it for all job postings, right? Which is what I mentioned earlier, kind of what I see a lot of clients doing, is trying as best they can to do a one-size-fits-all approach. It is hard, I will tell you, because some of these states, their requirements are different, right? Some say, give just a range of pay. Others say you need to include things such as bonus potential and benefits as well. So it can be very difficult and complex to get a one-size-fits-all thing. But at least 40% of these organizations say they go ahead and do it for all job postings. It didn't get into the nitty-gritty where it said, well, what do you post? And whether there's variation in that. But overall, the approach is they're going to be doing job postings with this pay scale information. 17% of the respondents said they'll only disclose it where legally compelled to do so. So that more of a piecemeal approach. And then 23% said they provide salary ranges, but not all job postings. So this last data point, which I thought was really interesting, deals with kind of this pay for performance mentality that a lot of organizations kind of tout. We pay our best performers better, right? If you perform, we'll pay you more. Like, that's a great meritocracy kind of thing to say, and it's a great motivator for employees. But 34% of these respondents don't necessarily ensure that higher pay goes to better performers. 40% admitted that they could not say with confidence that they ensure that the higher pay goes to those with the firm. So that could mean, any number of things, like they're failing to have regular performance reviews that connect to their pay decisions. Maybe they don't do metrics or auditing. I don't know, but the report didn't get into that level of detail. But I thought that was really interesting, because a lot of times when we do these audits as well, we often are looking at performance information, whether you use ratings or some other factor to evaluate your employees. We oftentimes are looking to see what that correlation is, because performance is a legitimate reason. It is a legitimate basis for distinction in pay. So anyway, thought that was kind of interesting. Folks confessing that they didn't think that there was a connection or correlation between performance and pay in their organizations. All right, so we mentioned audits, and we mentioned that there is no longer the requirement on the federal level to do affirmative action planning, which involves these annual compensation audits, such as they were. But what do we think now about audits? How, now that these rules are somewhat changing, should we be doing audits? I will always tell you that doing an audit is still the best line of defense, even if you are not required to by the federal government, or there's no longer that sort of federal compliance pressure. It is still a very good measure of employment compliance as an organization to do the audit and see how you're doing as an organization. There are a number of reasons, not just legal reasons, to do an audit, but I will say, number one, the pendulum is going to swing back. I mean, if history is our teacher, where we are right now from a federal law compliance perspective is just one side of that spectrum. The pendulum does swing back and forth. And so eventually we will be in another environment where there might be more scrutiny again with respect to our compensation practices and compliance. And in that case, it seems to me that we should be keeping our house in order now, rather than waiting until we're told we have to do so. It would be a lot harder to pick up things and correct things down the road if we're waiting to be told we had to. Those of you who have done employment audits or compensation audits know that sometimes correcting them come with a pretty big price tag, but you're making traction over time to eliminate or minimize those discrepancies. So if you just take her off the ball for a number of years and then try to jump back into it, I would suggest that that's going to be a much more costly proposition than keeping up this diligence as time goes on. Second thing is, it's the right thing to do, right? We should be looking at our organization to make sure that we're paying our employees without regard to any protected characteristic, that we're paying them fairly, that we are what we say we are. If we're a pay for performance company, that we're paying people for performance. We should be looking into that. And there is going to be a definite result that that's going to have on employee engagement, employee retention, and yes, legal compliance, because some places will still require that you do salary reporting. So you don't want to take your eye off that ball altogether. Helps keep your finger on the pulse of the organization. Do we have problem areas? How are people doing? How are our managers doing? Are they good managers and managing their people? The information that we can glean from these audits definitely helps us keep our finger on that pulse of that organization. We also want to use it. We can use it to help develop really good compensation strategies. Are we doing things the right way? Are we focusing on the right things? So anyway, there are a lot of non-legal reasons where you can utilize internal audits for pay equity. And I challenge you all to look at that and use those as a rationale to go forward and keep doing this really good work. Next thing is, public opinion is not going to change on this. No one that I know is going to say, yeah, we should pay people differently because of their gender or because of their race or, because of whatever XYZ protected characteristic. At least no one says that out loud. But here's the thing that, if you look at it, like, let's say you get sued and you have a pay discrimination lawsuit, whether it's on a class basis or it's on an individualized basis. And let's say you get to a court, where they rule on it. They don't grant you summary judgment, so you go to a jury. A jury, public opinion, and your jurors want to see that you're doing the right thing. And that is not going to change. There are so many studies out there that say that jurors tend to focus on what's right and their feelings of right and their feelings of justice as opposed to the law. So, the generalized expectation about pay equity is not going anywhere. So anyway, hopefully I've convinced you not to abandon your efforts and keep up doing your pay equity audits. And I think that that's the best practice among a lot of organizations is to keep that going. Now, I do have a little caveat for you about attorney-client privilege and your audits. So a lot of times organizations utilize either in-house counsel or external counsel to oversee and manage the audit in order to protect it by the attorney-client privilege. And that is a very good strategic decision, particularly as you're starting out on these audits. You want to protect as much as possible the thought processes about how to conduct the audit. What are we going to do with the results of the audit? Want to have protected by the privilege so as to minimize the risk of exposure overall. That's why we do it. But there is actually, there's a case out there recently where a federal judge ordered an employer to produce its pay equity audits and results in litigation, finding that they weren't privileged. So I want to call that out because it is a decision, but the logic behind it, kind of makes sense. But the case, for those of you who are interested, is it was filed against Thermo Fisher, and that company, they did it's a very big biotech company. They did an annual audit. They posted the results of their pay equity study on a sustainability report that was publicly available. They did all the things that were saying, like, hey, we're a great company. Look at what we're trying to do to move the needle. But there was a lawsuit filed against it for pay equity, and the plaintiff's attorney wanted to get a copy of the analysis, the data and the analysis and the report. The judge, though, found that it wasn't privileged because the audit was prepared for a business purpose and not a legal purpose. He then said also, even if it was privileged, it would, the company has waived the privilege by posting it and talking about it in this business related context. So it was kind of a double whammy for the employer. And so just a couple things that the judge looked at, which might resonate with some other organizations. One, he looked at the engagement letter for the audit and noticed that the reasons that were stated in the engagement letter with the law firm and with the third party who conducted the audit for them didn't mention a legal purpose. It mentioned things about internalized pay equity and just more general business purposes rather than legal compliance. But I think what the real clincher was for the judge here was, as I mentioned, the company had referenced the study in its social responsibility report that was posted on its website. And that report said the study was done for progressive and equitable purposes as a whole to ensure our employees receive fair, competitive, and equitable pay. So again, drawing attention to those non-legal purposes for conducting that study. And then again, as I mentioned, that the court said, well, hey, even if I'm wrong and this report is privileged, Thermo Fisher, you've waived any privilege that you have by posting it and promoting it externally. So lesson learned from this. I mean, hindsight's 2020, right? I mean, who knows? They might have thought they did everything that they could correctly at the outset to protect this as much as possible. But now that we have this ruling, some kind of takeaways are careful how you set up that audit. You certainly should engage an attorney. I would say that whoever it is, especially if you're not very experienced in conducting these audits, get insight as far as how to set it up, and hopefully you can protect some of the methodology and decision making through the attorney-client privilege. All right, but if you take that step, document the legal purpose for the analysis early on in the communications, and treat the analysis as if it is attorney-client privileged. A lot of times, once we get going with these audits and we start working with all the departments in the organization who are pulling the data, and we're all talking about it and everyone's excited, we sort of lose the universe to whom it is disclosed gets bigger and bigger and bigger. And that can come back and harm any argument that this is truly an attorney-client privilege document, because if something is that special, it has a limited audience and is used for a limited purpose. So you have to be really thoughtful about how broad you go, how it is communicated beyond the immediate circle, things like that. All sorts of fun stuff to keep in mind as you're going through your audit. Everything is eminently doable, but just keep that in mind as you're structuring your audit, and continuing to realize that, yeah, this is data that in the wrong hands can be harmful or embarrassing to an organization. But I would suggest that that's not a reason not to do it. You just need to be very mindful as to how you do it going into it, so you can be as protected as possible. All right, so on to some more interesting kind of like anecdotal stuff. I tried to pull information from a number of cases where employers have been sued, usually on a class action basis, and to see kind of how those cases are shaping up. And as is common in this day and age, a lot of these larger actions ultimately do resolve by way of a settlement. And those settlements have to be approved by a court. So that's why they are often published, and we see a lot of articles, and we can see a lot of the case filings on them. And so we have this great bevy of information about some recent settlements. So a couple of these are really interesting, and I think there are some definite learnings. And I would also say use the sticker shock associated with some of these settlements. If you have any outliers in your organization who are thinking pay equity is not a good idea, we don't need to tackle it, look at these settlements. These are definitely significant settlements. And even certainly for an organization that is not the size of some of these companies we'll be talking about, but we got to pay attention to it. So, okay, the first one is a Disney, involves the Walt Disney Company, and this is a California case. The settlement was just announced. It has not been fully approved yet by the court. According to my latest research, as of earlier today, there's a hearing set in September to approve this, but this is what has been publicly available based on some court filings and some news that we've seen about it. So this was a California Equal Pay Act class action that alleged that Disney systemically paid women less than male employees with the same experience. So in May, the court preliminarily approved a $43.25 million settlement on behalf of a group or a class of about 14,000 employees. The suit itself was filed in 2019, and it challenged some of Disney's policies. And this is what's kind of interesting. One of the policies that it challenged said that they based a new hire salary on their pay at a previous employer. So we know that's a no-no now. Also under California law, but also just in terms of the case law too. Now this was an older policy, so Disney probably just kind of got caught up in it. But anyway, so it challenged their policies. One was how they based the new hire salary, which resulted in discrimination against women. And then what was kind of interesting in this case is that a study that the plaintiffs' counsel ran on the compensation for all these putative class members was that one category of women was paid 2% less than their male counterparts, while another category was paid only 0.58% less. So what does that tell us? Seems like Disney was doing a pretty good job in terms of closing up that gap. However, that does not necessarily inoculate them from such a big lawsuit like this. So how this case kind of originated, and the story might sound similar to those of you who deal with this. One of the plaintiffs, the named plaintiff, Miss Rasmussen, she was a financial analyst, and she just sort of accidentally discovered that 6 men with her same job title all made significantly more than she did. So she brought it to Disney's attention. She received a $25,000 raise, but she was still paid less than the average male compensation from that group. Now under the agreement, and this is a theme that you'll see with some of the other settlements that I'm going to be talking to you about, the company also agreed as part of the settlement to hire an outside industrial consultant to train employees on benchmarking pay levels. They'd also engage a labor economist to continue to work for the company over the next 3 years to conduct pay studies. So, it's this remedial component to it. And again, we're seeing a lot of that now. But the question or the concern that I would have with this is how much do they have to report their doings to the other side or to the court? I don't know. That's probably in some sort of decree. But there's an important kind of remedial measure associated with this settlement. And, of course, that involves increased cost too for the employer down the road. All right. So the next case or next settlement I want to talk about involves Google. This was another California Equal Pay Act case. Don't worry, I have non-California examples as well. But this one alleged that Google favored white and Asian employees over other minority classes. And this was a $28 million settlement that was preliminarily approved in March 2025. So this case was actually filed in 2021, and it alleged that Google paid employees who identified as Hispanic, Latinx, Indigenous, Native American, American Indian, Native Hawaiian, Pacific Islander, and or Alaska Native less than white and or Asian American employees for substantially similar work. And I will just say a little side note, that tends to be what, I've seen this a lot in some pay analyses where when you take out the white employees and you take out the Asian or Asian American employees, it's those other groups that are paid disproportionate levels. So kind of looking at minority, non-minority, or doesn't always do the trick, because the Asian American or it might be some other ethnic category might be higher paid, higher compensated, and that will skew your data. Anyway, so this case alleged or they saw that experience where the white and Asian American employees were making a lot more than these other smaller protected characteristics. So part of the policies that were being challenged in this lawsuit too, or the allegation, was that Google had a practice where it started new diverse hires at a lower salary and a lower job level than the white or Asian employees, in part because they would base the starting pay and base level assignment off of where that employee had at their prior employer, right, which just kind of perpetuates these historical discrimination trends. Plaintiff, though, here also relied on a leaked 2022 Google employee internal pay sheet, which shows that the diverse employees reported lower comp than the white or Asian American employees. So, there goes that privilege or that cone of silence or that confidentiality that exists with our pay studies. That report got leaked. And then plaintiff went to their own labor economist and said, hey, look at this data, and there you go. All right, so we've got a $28 million settlement. Again, there is this remedial measure here where Google also agreed to work with a labor economist and an industrial and occupational psychologist to review its annual pay equity audits and the process for determining the level at the time of hire. And just as a side note, Google also recently settled another race discrimination class action alleging racial bias for $50 million. And that claim or that case involved allegations where they allegedly steered Black employees into lower paying jobs, paying them less and denying them advancement. And again, as part of that settlement, they also agreed to take steps to ensure transparency and fairness. So kind of a double whammy there for Google. Next settlement that was really big this year, and I saw this get reported earlier this year. In January 2025, MasterCard agreed to a $26 million class action on behalf of 7,500 female, Black, and Hispanic employees. This is a case out of New York. I haven't done the math to figure out how much each person gets. That is certainly a smaller type of group that we've seen in terms of class. It's still a lot of employees, but the other ones had much bigger class sizes. So this was a race and gender class action challenging the hiring, advancement, pay, and promotion practices at MasterCard. Specifically, the plaintiffs alleged that discriminatory hiring and advancement practices included giving underrepresented workers lower paying jobs, which they were overqualified for, and fewer raises and promotions than their white male counterparts. So, really kind of interesting. Didn't just focus necessarily on the entry level thing, but then also kind of as they progressed through their employment. So, kind of goes to show that maybe we should be looking at, in addition to pay, look at our promotion processes as well, to ensure that those opportunities and raises are not being done in a discriminatory manner as well. But here, as well as what we saw in the others, in addition to the monetary payment, MasterCard agreed to hire a psychologist to identify bias within the company and will conduct pay equity audits moving forward. What MasterCard has stated in their, I've seen the statement by MasterCard out there about this. They've said that we think this provides a framework for other companies in the industry to improve their practices. This is a really good example of a large company trying to kind of set a trend maybe for others in terms of we need to be looking at this information and we need to be constantly evolving and doing better in this area. All right, last example of another settlement. This is probably a couple years old, but I thought it was still a really good example and had some good learnings for us. This was a lawsuit filed by the EEOC against the University of Denver. This was a gender equity class action under Colorado in federal law based on a failure to rectify pay following an equal pay audit. So I'm just going to pause there for a second because that is one of the biggest things that come out of an pay equity audit. And this is a question we often ask before you embark on a pay equity audit is, what do you do with the data that you find? And if you don't have the appetite or the buy-in to actually do something about the results of a pay equity audit, you probably should not embark on that. One, it's, the utility of that effort is questionable, shall we say. Why spend the time and resources doing an audit if the report's just going to sit in a drawer and nothing be done with it? The other more legal answer to why should we do something following a pay equity audit is, if you are found as an employer to have knowledge about these potential discriminatory practices or this disequity with compensation, and you do nothing about it, that could expose you to punitive or liquidated damages, under the auspice of this is a willful violation, or you've shown reckless disregard for your obligations, as an employer under these discrimination statutes. So you actually might be doing more harm than good if you do an audit and not be prepared to take steps or at least have a plan in place. So anecdotally, I don't know all of the specific situations here with the University of Denver, but this was a significant allegation that the EEOC had levied in this case, which very likely contributed to this $4.5 million class action settlement for 386 class members. So the lawsuit asserted that the university had conducted an equity review in 2021 and had determined that 386 female identifying faculty members were being paid less than similarly situated male faculty members. Now, although it looks like the university gave these female employees raises, they didn't go and give back pay to them to make them whole up to the present point. Another little footnote there, that is a question that a lot of employers have to deal with too, right? How do we address pay equity? Do we just give them pay now, so going forward, they're on better footing, or should we make a retroactive payment to bring them current? In this instance, the university opted not to pay back pay, but just said, hey, going forward, we'll fix you now, and then going forward, the effects of this are going to be minimized for you. All right, so interesting. In addition to paying the money, they also agreed to conduct follow-up pay equity reviews every 3 years, and make the wages of faculty and job applicants available to the public. All right, so let's move on. I think those are really interesting settlements, and some of the facts give us some really good food for thought in terms of how we are going to be organizing things ourselves, or things that our organization should work on. But as we kind of get into the home stretch here a little bit, rounding it up, the benefits of maintaining a focus on pay equity has not changed. Hopefully you got that from this session. There are definite strategic benefits of pay equity that persist even in our current climate of decreased federal regulation. We still see requirements imposed by the states, and certainly lawsuits abound. So it's definitely a very good practice to maintain these. So first off is legal compliance, right? We've talked about that. We need to constantly maintain legal compliance where it exists, and that patchwork from the states, as well as developments from case law, are constant challenges that we need to be aware of and that we need to look at. And failure to comply with that can continue to result in litigation, fines, reputational harm, as well as economic harm. These settlements are hefty settlements that we're seeing. Don't forget about the impact of pay equity has on talent attraction and retention. Workers, particularly younger workers, are increasingly evaluating employees or employers based on their commitment to paying employees fairly and transparently. And also, there are lots of studies out there that show that the impact on employee retention, when employees understand how their pay is calculated, and that it's fair and that there's an element of transparency to it that all increases retention and employee loyalty. The culture improves with employee management and morale. If employees feel they're not being paid fairly, definitely has a negative impact on employee morale. Very negative perception of the organization can exist internally and externally, as well as employees might post their Discord on social media and things like that. And then on the flip side, employees have reported feeling higher levels of engagement when they're paid fairly. There's an impact on reputation and brand as well. And there are a lot of studies out there that show that there is a competitive advantage, for employers with job seekers. And anecdotally, job seekers asking questions about pay equity and how pay structure is designed, developed, and what their opportunities for advancement are within that. So all good things come from pay equity and continue to keep our eye on that ball. So rounding up and going back to my DCC team here. So pay equity lessons from Dallas Cowboy cheerleaders and a lawyer. Number one, be persistent and work hard. Keep up with your audits, maintain your internal controls. Don't take your eye off that ball. It is a lot of hard work. It can be expensive. Yes, there are risks both sides, but I would suggest that the risk to not doing anything is far greater than the risks associated with undertaking this effort. So continue to work hard with that. Always strive to improve. Keep up to date on the new changes that are coming down the pike and developments, and be prepared to adapt with them. Something that I have sort of seen over the last couple of years as, these pay transparencies laws have become kind of more the norm, that we kind of have delegated them to a subset of HR or recruiting to pay attention to and look at. And that's great. That's great. But, we should continue to have a higher level strategic focus on it and not just kind of check the box that we're doing this, but be really thoughtful about how is that integrating with our bigger compensation strategy with the organization, and how can we continue to improve in that fashion. And then the final lesson that I've learned from the Dallas Cowboy cheerleaders is that fair pay and treatment is good for business. What was really interesting about this show and kind of resonated with me as kind of a HR lawyer and fan aficionado was how at least how the show portrayed that the leaders of the team addressed the members' issues with pay equity. So there's the choreographer and the DCC director, kind of the mama bears of the team. When the show showed that the cheerleaders were coming to them with their pay equity concerns, they listened. Okay, they just sat and they listened to them. They were fair to them. It didn't seem like they were trying to be the bridge between them and upper management, whoever it was. And granted, I don't know what happened behind the scenes, but how they reacted to them. They listened to them, they supported them. And they did talk a lot about, hey, listen, you need to look at your baseline comp in terms of your total rewards, but they didn't minimize them. They did appear to be very supportive of them. And eventually that sort of trust relationship that the employees had with their choreographer and chairperson led to success for them in the long run. And now we have a wonderful set of cheerleaders who are super engaged and super happy. And so, it all worked out very well in the end. So I think that we are coming up on our time. So thank you very much. Let me share with you our SHRM activity code and the HRCI activity ID. As Victoria mentioned, we will be making this available to everyone, the slides as well, to our participants. And I apologize, we did not get to any questions whatsoever, but if you did submit them, we will definitely follow up with you individually after the fact. So I thank you so much for your time and attention. I hope you enjoyed this as much as I did, and have a great day.